This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing & Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
As promised, Todd Lutsky now joins us for Ask Todd. This is your chance to ask Todd your estate planning questions live on air. Phone lines are open at 888-205-2263. That is the number to call to ask Todd your estate planning questions live right now. 888-205-2263. We can usually get to somewhere in the ballpark of 2 or 3 questions. So if you've got one, get calling early to make sure we get to you. 888-205-2263 is the number. Mr. Lutsky, how are you doing today?
I've been a little better. I'm going to gut through it, though, but I'm okay.
You're okay?
Kind of okay. And you?
I had a tough day yesterday.
Yeah,
I
me
did.
too.
You might not know this. My night job is as a plastic surgeon.
Really? That's fancy.
I know. Thank you. But I had a patient yesterday, and I really messed up his surgery.
Yeah, how'd you do that?
I'll never forget the look on his elbow. It's not good. Todd, I want to talk to you a little bit about beneficiary naming. Let's say that someone has not done any estate planning. No will, no trust, no nothing. Conventional wisdom in terms of naming beneficiaries on financial accounts. Best practices. What does that look like?
Oh, I'm not sure you can use the word best practices with naming
best worst practices.
That seems like an anomaly. So I think the way to do it is if you're going to name a beneficiary, well, we can talk about it 2 ways because there's 2 types of assets. There's qualified assets where you definitely need to name a beneficiary.
Sure.
And then there's non-qualified assets. Let's just stay with banks and brokerage accounts.
Sure.
So non-qualified accounts, can you name a beneficiary? Yes. Does it always work as the best way to avoid probate? Well, it will avoid probate every time, but is it a good way to avoid probate? Well, yes and no. I mean, if you're going to have a trust in place and you're not going to retitle the name of the asset to the trust, the brokerage account or the bank account, at least name the beneficiary, the trust. So then it would get to the trust and then it would fund it at death and make sure your assets, go where they're supposed to go and be sheltered for estate taxes. So that would work great. But if you're not going to have a trust and you're going to use designated beneficiary thinking it's cheaper and easier than using a trust, then you have to be careful because if the beneficiary is each other as a spouse, then it's just joint, well, that doesn't save anything for estate taxes at all. Everything just passes to the spouse, and you waste exemptions that you could be sheltering assets for. And if you're single and you're starting to name children as beneficiaries, then be careful because if you don't name all the children and you name one child on certain accounts and one child on another account, the likelihood is you're not going to be treating them equally.
Sure.
And you might want to, so that's a concern. But with IRAs, you do need to name a beneficiary because those you cannot title to the trust while you're alive. Cannot retitle the owner, but you need a beneficiary. So in that case, if you're married, obviously the first one is always the spouse. It's the best of both worlds when you're doing estate planning, ideally. And then secondly, you could name kids, but again, if you're going to do a trust, I would name a trust as the contingent, generally because I don't want assets going out right to my kids, especially if I have a large IRA. I want those assets to be, sheltered and divorce-proofed and generation-skipping benefits and whatnot, which is probably what I'm doing with my trust assets. So then I might as well add it to the trust when I die to get those added benefits.
Talking with Todd Lutsky from the law firm of Cushing & Dolan. Still do have a bit of room on the phone lines at 888-205-2263. That's the number to call to ask Todd your estate planning questions. 888-205-2263. We are going to take a quick break, but when we come back, it's right to your questions with Todd. Again, that number is 888-205-2263.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network. You're listening to Ask Todd with Todd Lutsky on the Financial Exchange Radio Network.
All right, let's get right to your questions with Todd Lutsky. First in the queue, we've got Bill in Wakefield. Bill, what's your question for Todd?
So my wife and I are retired, and I have several multi-family houses and several kids. And right now I'm using the income for my retirement, but at some point I want to leave one house to each of the kids. So I'm trying to avoid the capital gains, but I also know at some point I might not be able to maintain the houses myself. So I'm wondering, right now they're in a revocable trust with the kids as the beneficiaries, but is there a certain point I should go to an irrevocable trust, and is that the best way to handle to keep the income and pass the house without realizing them having to pay the capital gains tax?
So let me just hang on. Let me ask you a couple of clarifying questions as we go through this. So, like right now, how much would you say the value of your overall estate is? More or less than the Massachusetts combined $2 million exemption each, which would be $4 million?
Yes, it's more than that.
Okay.
And my wife and I have a trust each, and then the trust that goes to the kids.
Well, that seems a little confusing. You could each have a trust, but it depends on how large your estate is. Probably one joint revocable trust would be good if you're not over the $15 million federal exemption. Are you up that high? No. So, but you're over 4, but somewhere under 15. So, whether or not nursing home planning is important, I can't tell from this. I would need to know how much income is being generated and whether or not, you want the irrevocable trust for a nursing home planning or not. That would require probably a sit down to really analyze, whether or not you're self-insured or you aren't. And if you aren't, then yes, we could do irrevocable, and it could be 2. And you could put these assets in them, and you wouldn't need to worry. And that's a great question, though, about step-up in basis. The irrevocable Medicaid trust planning that we do for folks gives you the step-up in basis when you die. So if you don't sell these rental properties before you die, not only will they avoid probate and be preserved for estate tax and nursing home protection, when the kids actually inherit them, they will get a brand-new basis. So if they sold them, there'd be no capital gain, or if they chose to rent them, they would pay, be able to depreciate them with a new basis over 27 and a half years against their rent. So that's a huge win for them. So don't know if that's right or wrong for you, but that definitely can be done. The only other comment I would have for you is if you are worth less than $15 million, maybe a joint trust, if it's revocable, if you're not going irrevocable, would be simpler and provide the ability to shelter more assets on the first death than dividing the assets between the two of you. That said, the only other comment I might have is multifamily units probably should be owned in an LLC. If they're in an LLC, then you're going to give yourself some creditor protection against potential lawsuits. So I would think about that. But yeah, sounds like you probably need a good sit down with an estate planning attorney and really look at your overall plan to see if a change is right for you. And you know what? That's funny because that's exactly what one of the things we talk about in our guide is, right, how do you leave assets to beneficiaries? Well, you want to leave these assets to the kids. I heard one house to each kid. Be careful because you end up, not treating everybody equally when you do that. There's other ways you can treat them equally and still ensure that they get, what houses you want them to get. Maybe a first right of refusal, maybe make each other buy each other out. There's many ways to think about it. And folks, there's other things too you run into when you're leaving assets to children. Do we want to divorce proof them? Do we want to creditor protect them? Do we have special needs children? We don't want to just rely on jointly owned assets. The question is great about planning, but the family behind the estate plan is also very important. So get the guide. We're coming up on the end of the month here. It's going to go away. 866-848-5699 or legalexchangeshow.com and get the guide as to how to leave your assets to your beneficiaries. Again, 866-848-5699 or legalexchangeshow.com, and you can always go to our Instagram page, Cushing Dolan PC, for much more information.
Todd, I got another one for you here. Let's go to Jeff in Sutton, Massachusetts. Jeff, what is your question for Todd?
Yeah, hi. Good morning, Todd.
Morning.
I have a process question. My wife and I are going to create a revocable trust for our family. We have 3 children. They all go along well.
Mm-hmm.
The will's going to state that they will receive equal share.
Mm-hmm.
My question is, should we appoint all 3 children for trustees, or would it be easier for the process to have just one child as the trustee? Do you have any pros and cons on that idea?
I do. So the trust language, when you're leaving it equally to the kids, is the trust going to simply say divide it and pay it out, give it to them, they walk away, or are you going to be holding it back in trust for some reason, creditor protection, divorce proof, etc.?
No, our plan was to divide it equally in the case of our demise and go from there.
But upon your death, is the trust going to say divide it and give it to them outright, or hold it in trust? What was your thought?
Well, we were just going to divide it outright and give it to them.
So if you're just going to divide it, and again, there's no right or wrong answer here, folks. It's just what's right for your family. So if you're going to divide and allocate it and pay it out, then there's no reason for sure to have 3 kids as a trustee, because what's going to happen is the trust is going to end right away, and the trust has to do exactly what, or the trustee, has to do exactly what the trust says, which is simply divide it, pay it out, trust over, everybody walks away. So I'm going to say 1 child is ample in your situation. Hope that helped.
Todd, we've got another one for you here. Let's go to Ken in Maine. Ken, what is your question for Todd?
Hi, how you guys doing? Yeah, I have a unique situation, and you guys kind of alarmed me just a few minutes ago that the IRS cannot have a beneficiary of a trust. I'm thinking about starting a trust. I'm kind of new to this. I'm 59 and a half years old. My wife is 60. I am currently retired. She works, makes about 50 with an adjusted gross income of about 18. Have about $2 million in tax deferred, and she has about $750,000 in a tax deferred, both rollover IRA, and I have about $300 in a Roth. And it seems I'm going to be putting myself up against a very difficult challenge of transferring a lot of that traditional rollover IRA to a Roth in the next 10, 12 years before the RMDs kick in. But it kind of alarmed me when you said a few minutes ago that the trust cannot be the beneficiary of the IRAs. So do I continue going as far as the Roth conversions, or do I have something creative that I could do that alternatively do?
So this is going to be an easy, quick fix for you. So what you misheard was that the IRAs cannot be owned by the trust while you're alive. They cannot be owned. You got to keep the ownership in your name. It's an individual retirement account, so it's in your name or in your wife's name. I did not say the beneficiaries could not be the trust. The owner cannot be. The beneficiary absolutely can be the trust. It's just a matter of looking at your overall estate plan and sort of trying to figure out whether or not we should make the trust the beneficiary or the kids the beneficiary. That's a function of what you're doing with your estate plan. But if the goal, perhaps unlike Jeff in his situation, he was just going to give the assets outright. But if you're saying, no, I want to try to hold these in trust, I want to protect them from creditors, I want to, protect them from my kids' future divorces and maybe make it down a generation to the grandkids after my kids die and get it there estate tax free. It's called generation skipping tax planning. Well, if that's the case, then all your other assets, not the IRAs, can be owned by the trust right away. Do that now. And then the primary beneficiary likely would be the spouse, and that's okay. Primary beneficiary on the IRA or the other qualified plan assets that you have. And then the contingent beneficiary, instead of being the kids, could be the trust. That way, not only are the assets that you currently own in the trust, but when you die, the other $2,750,000, if I heard the numbers right, find their way to the trust to be sheltered and paid out for your kids over time. Again, the 10-year payout's still going to exist either way. And then what will happen is the IRA will just be, you just reach into the IRA and pull out some money and put it in the trust over 10 years. So that's the way I would do it if you're going to go ahead and do your estate plan and try to protect all of your assets. Beneficiary, contingent beneficiary can be the trust, but probably not the primary.
Mr. Lutsky, thank you so much for joining us today.
Well, thank you. It's always a pleasure.
This has been Ask Todd on the Financial Exchange Radio Network. Ask Todd with Todd Lutsky has been presented by Cushing & Dolan, serving Massachusetts and New England for more than 30 years, helping families with estate and tax planning, Medicaid planning, and probate law. Call 800-393-4001 or visit CushingDolan.com. The views expressed in this segment are solely those of Cushing & Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing & Armstrong do not endorse each other and are not affiliated.